Welcome to the Asian International Arbitration Centre i-Arbitration Webinar 2021. This webinar is held in collaboration with the Advocacy and Mooting Unit of University Utara Malaysia. The title for the webinar is A Broad Spectrum of Opportunities Towards Advancing Islamic Arbitration. We have Mr. Abdullah Abdul Rahman. Mr. Abdullah has been recognized for dispute resolution by the Legal 500 in 2013 and for contentious banking and finance by Asia Law in 2018. He holds the Chartered Islamic Finance Professional from the International Centre for Education in Islamic Finance. Next, we have Dr. Mohd Zakhiri Muhammad Noor. Dr. Mohd Zakhiri is a senior lecturer at University Utara Malaysia with 14 years teaching experience. His area of research include Islamic law, banking and finance, Islamic capital market, Islamic wealth management and Sharia studies. Recently, he was appointed as the AIAC's i-Arbitration Rules 2022 Revision Committee. Last but not least, we have Mr. Shafiqi. Mr. Shahizan is a senior case counsel at AIAC. Meanwhile, he is currently pursuing a Master of Corporate Law at University Utara Malaysia. He also completed certifications from the Malaysian Institute of Corporate Governance. It is also noteworthy that Mr. Shahizan is a mentor of the National Scholarship Program focusing on commercial, comparative and constitutional law.
And allow me to take this opportunity to express our gratitude to you all for supporting today's webinar. Special thanks to our friends from UUM and to the esteemed speakers. Thank you very much.
Arbitration in Islamic law is what we call race-free or religion-free. So you need to follow the Sharia principles has been laid down. So that is the value that we possess. And in fact, we see in the book by Professor Naim Yassin in his book 𝐀𝐈𝐀𝐂 𝐈-𝐀𝐂 where he quote the views of Imam Nawawi. So we can appoint the arbitrator even though he's not a Muslim, so long that he can disperse his judgment in correct way based on Islamic principles and whatnot. So as far as the parties is concerned, it doesn't matter whether you're Muslim or non-Muslim, Malaysian or non-Muslim. So we need to follow the standard procedures, and that has been, laid down by the regulators and the like.
In matters of Islamic arbitration, and in particular the subject matter that we are talking about. So if it is an Islamic finance contract, or perhaps any dispute should be referred to an Islamic finance expert with the wording of the clause, arbitration clause suitably worded. So that is, I think, how legal firms or legal professionals can assist.
Section 56 and 57 of the Central Bank of Malaysia Act. Those particular provisions are not specifically or expressly mentioned in the rules to ensure that prevailing or emerging similar centralized functions, Sharia functions in other jurisdictions can also be applicable to the i-Arbitration rules. And also that, where the governing law is concerned, if it's not Malaysia, then the Central Bank of Malaysia Act will not be applicable. So that's also another reason as to why it's not expressly mentioned in the rules.
Let's move on to the Q&A session. Allow me to express the questions on behalf of the audience. So the first one, we all know that the sources of Islamic law originated from Al-Quran, Hadith, Ijma and whatnot. Will these sources be implemented or taken into consideration during the proceeding of i-Arbitration? Dr. Zakhiri, if you may answer this question for us.
Thank you for that particular question. Of course, when it comes into dispute resolution based on the relation, we need to refer to Al-Quran and the Sunnah to resolve the dispute. But as far as arbitration is concerned, it pretty much depends how the parties, or rather the council, Sharia councils, tender the opinion before the arbitrator.
To my mind, depends on the law that is agreed by the parties. So actually there are several laws that are involved in an arbitration. First, you have the law governing the substance of the dispute. Second, you have the law governing the seat, or basically the procedural aspect of the arbitration. Third, you have the law governing the arbitration agreement.
Reading through the comments and the questions, there's quite a bit regarding different school of thoughts or mazhabs. And I think looking at Rule 5 and 6 on serving notice of arbitration and the response to notice of arbitration, where specifically parties can specify the application of any Sharia principles. Now that in itself is, to me, a means to facilitate specifying any particular Sharia principles that the different mazhabs would want.
Thank you to all three honourable speakers, Mr. Abdullah Abdul Rahman, Dr. Mohd Zakhiri, and Mr. Shazrin, for your time and the knowledge shared with us today for today's session. So, as the moderator, I would like to announce that this marks the end of our webinar session. And to the audience, thank you for your time, thank you for your loyalty, for spending 1.5 hours with us.